Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody. Today, we are talking to Jennifer Felten, who is as close to real estate royalty as you can get. And let me tell you why. She started in title, then she went to escrow, then she went to law school. And so, with that wealth of knowledge, I'm in awe. Jennifer, welcome to the show.
Thank you, Matias.
So let's get right to it. Today, we're going to be talking about a partition action, which is something very relevant to the world of probate and trust. So first of all, Jennifer, can you tell us, what is a partition action?
So a partition action is a legal remedy, right? So you go to court when multiple people own a piece of property and cannot agree on what to do with it. Maybe some of them want to keep it, maybe some of them want to sell it, and there's this dispute over retention. It commonly occurs in inheritance probate type situations where family members inherit and they don't have the same plans or desires, right? So that's it. The goal is to give us a legal way to deal with it if we can't cooperate.
Very good. That makes total sense. Now, if people don't get along, then you get the court involved. That's true in any area. But particularly in the world of when somebody inherits a property. Often the case is there are siblings and maybe, sometimes brothers and sisters and sisters and brothers don't get along. I myself have 4 kids, so who knows, hopefully they'll get along when that day happens. When the court gets involved, what are the general rules that somebody can expect to be dealing with?
Right. Well, and that's part of why this is such a really relevant topic right now, is the laws have changed in the last couple of years in California as to how partition actions occur. So traditionally, if a family member or someone filed a partition action, the first thing the court would do is do what they would call a partition in kind. So that's the first potential remedy. That means split it up, right?
Okay.
So they cut it in half, like, Solomon and the and that's the first choice, right? That's the first legal remedy. But it's very impractical in most situations, right? We're not cutting the house in half or in quarters right? So you'd have to have the right property, the right set of circumstances for that to be an actual viable remedy. But that's the first thing the court looks at. Can everybody keep it and just split it into shares, right? If that's possible, they do that and we're good to go. 99.9% of the time, that's not possible. And so the next remedy, which we have traditionally had, would be sale. The court would order the property to get sold, and then the proceeds would be distributed based upon percentages of ownership.
Got it.
The problem and the issue with that remedy historically has been, we're taking a property and auctioning it off. Right. So you're not going to get the same value as if you listed the property and, put it out for sale, lower property values. And so the heirs often didn't get the fair market value for the property historically. And unfortunately, when you look at history, the families who often suffered the most, low income, minority, right, because they often didn't have the resources to buy the property themselves. Okay. So it's been historically a very challenging thing for a lot of families. And think about, grandma's house, you want to keep it. You want to keep the property in the family versus some stranger taking over grandma's house, right? For those people who want to keep it. So last year, the legislature changed the law and they created this Uniform Partition of Heirs Act. And so they changed how the remedies work. So now the heirs have what's called a first right of refusal. So if I inherit a property with my sibling and I want to sell it and they don't, and I file a partition action, I don't have that remedy, but the other people do, right? So the people I sue because I want it sold, they get the first right of refusal to buy the property, before it goes sold on the open market. So it's about keeping the properties in the family and allowing this generational wealth, right? That's the concept of keeping it all in the family. And so that was the change last year that we got in the codes to try and help these families and give this priority to family members. We liked it so much that we actually expanded it this year. So we're using the example of a family, but a partition action could happen on any type of co-ownership.
Right.
You could co-own not because you inherited, you could co-own for a whole bunch of different reasons.
Of course.
You know, partners go in and they buy a property, divorce, right? There's a million types of situations. So they changed the law for 2023 that any co-owners will have this automatic first right of refusal.
Okay.
If that doesn't work, right? If the family can't buy it under these rules, they now actually have to list it with a realtor and get fair market value. And then the court has to affirm the sale before it's sold. So there's a whole bunch of protections designed to, again, get people fair results out of these disputes over property.
So now it becomes very similar to, you have a court confirmation. You have a court confirmation sale. I don't know this because this law is very new. Do you know if there's going to be an overbidding process or?
Yeah, it's not, because it's going to be listed with a realtor for fair market. So it's not, it's just that the court has to confirm that it is a fair reasoned offer. It doesn't have the built-in overbid like a non-full authority probate,
right,
or like a receivership, right? As receivership would have overbidding as well.
In the probate world, you often have a probate referee who does a probate appraisal.
Right.
And you have to sell within 90% of the appraised value, unless you get the property reappraised. So in this case, it would be interesting to see how this law, if, they determine, because the court, will have to have some kind of knowledge to see whether, because I mean, realistically, we know that there's a lot of nefarious activities happening in real estate, unfortunately, like in every business.
Right.
So somebody could list it with an agent who is part of this concoction and wants to sell it to the cousin or whatever, and they end up not getting fair market value. So hopefully there are protection in place for those scenarios so that the court has an idea of what fair market value is.
Valuation is part of a partition, right? That is part of the process today. Right. It hasn't always been, but it definitely is part of the process today. But unlike probate or like a receivership, some of the things we've been talking about, which are very statutory, there's a probate referee in probate. So there is a specific person who does that valuation. We're in civil court versus probate court, and the rules are different. So you have private appraisers evaluating property versus a referee, and the court has broad discretion. Whereas in probate, there's a bunch of rules the judge has to follow. In probate, this is what's called an equitable cause of action. So our legal system developed from English common law, right? So in England, when the law developed, there were two sets of courts. There was the court with the king, right, which is the law court, and there was the court with the church, which was the equity court, right? So our legal system, some things when you go to dispute in a court, it's at law, and some things it's in equity. We have kept that system up to today, right?
The difference between stare decisis, so case law, and statutory law,
correct,
which is
and the judges have discretion, right? So it's about equity. So we're back to Solomon dividing the baby versus looking at a set of baseline laws. So probate is statutory, right? So they have very strict rules. Partition is equity. So the judge can do whatever they want to try and make it fair, right? We're trying to get to fair.
Yes.
So it's more loose for sure. But that also means if we're trying to solve a problem and we're trying to get cooperation, we have more leverage and ability to do that than we do in probate, where we have all these rules we got to follow. So there's pluses and minuses.
That makes total sense. Now, let's talk about this. Let's talk a little bit about this right of first refusal. When you bring the partition action, so the petitioner, I guess in this case would be that's petitioner in the court for aggression, will not have a right to purchase the property. So you better know that if you are going to be filing, you better be filing too, because you're either going to sell, you know that you're going to sell to your partner, to your siblings, to whoever buys it, or it's going to be sold in the open market.
Right. If you are filing the partition action, don't plan on buying it, right? If your goal, because this is, again, we got this family dispute, Well, maybe, one guy, one brother has unlimited assets or significant assets and the other
Mhm.
brother doesn't. So he's just trying to get his brother's share, right?
Right.
And so if he forces this, partition, and he can just buy his brother out, it's not fair, right?
Right.
Again, we're going back to fair. And so that is why the rules are set up the way they are. If you file, you could still end up potentially buying it, but you're not going to have the first right to buy
You
it.
could buy it in the open market. You could
Right.
submit an offer to buy the property. That
Right.
makes total sense. In my world of probate, what we see a lot happen, I shouldn't say a lot, but you see it often enough, is that the parent passes away. This is the scenario. And one of the siblings may be still living with the parent at that time, maybe taking care of the parent.
Right.
So
Right.
they have
Or
an interest.
mooching off the parent.
Yeah, you can look at it either way.
It
Either way,
happens both ways, right? There are some who are truly caretakers, and
right.
there are some who are just taking it what they can get, right? It's both.
So most of the times, the deadbeat brother, let's just give this imaginary
Yep.
person a name, the deadbeat brother
Yep.
can't buy the house,
No.
can't buy the house, can't pay rent on the house, can't do anything other than staying in the house. So when this partition action takes place, in that case, it will then be up to, through the process, to vacate the premises, I guess.
Correct.
And in a sense, the person who is living in the house, in this particular example that we talked about, they're still beneficiaries. So they'll be getting, whatever percentage is in the will or in the trust or whatever is due to them.
Potentially, yes. I mean, again, depending upon what was written in, if it's a will, you can look at all kinds of different circumstances. But usually the deadbeat kid is the one the parents want to take care of the most for some reason.
Yes,
right?
It always works that way. Yeah, it's true. It's true.
Yep. But yes, your scenario is right. So their interest is going to be part of this, and getting them out is going to be part of this.
Yes.
Discussion. So it depends on where in the process this happens, on how this works, because the probate court can do some of this stuff, right? If we're doing it through probate, we either can sell it and get the family member out, or we can distribute partial ownership. If we distribute partial ownership, then we got to go to partition. We're out of probate because now the estate doesn't own it. It's due. Then we're in partition land, right? Because now we have co-owners. When an estate is still being managed, we're not in partition land, right? Because we don't have co-owners.
Of course.
It's when it's been distributed and deeded to the children, that's when this would become an issue, right?
That makes total sense. Well, this is a very fascinating subject, and something that, a lot of people have to deal with. They will encounter this situation. Hopefully you get along, everybody that's listening gets along swimmingly with if this were to happen to them, with their siblings, so they'll never have this issue. Before we let this subject go and get to you, the person who purchases the property, they have a right of first refusal only of the interest that they don't own, obviously. So after a fair appraisal value, they say, okay, you have to come up with 50%, for instance, or whatever percentage you want to buy out. Okay, very nice.
Yes, so they can finance their percentage, right? And a lot of times that's what happens, is even avoiding, even through probate, right? If one of the children wants to keep the property, they'll finance it through that and take title, so that the cash is then available to give to the remaining siblings on the property.
That's actually very good that you bring up the financing option. So there are lenders who would, I guess their equity will count as down payment or something. Right. Yeah. Okay, that makes sense.
So it depends on the lender on how they structure the deals. So and so we'll start getting into the weeds, but there's property tax issues, there's capital gains issues. So there's a whole bunch of things that go into the decision making of how we do it. So if we keep title so say it's a trust, right? And we're trying to deal with a trust distribution. If we keep title in the trust and one of the kids moves in, we don't get reassessed, right? If it's the family home, so we can avoid property tax reassessment. And then they can borrow to pay off their siblings over time. So they're paying the trust. It's an installment sale of the property.
Oh, that makes sense.
The trust, so that we keep the property tax. So this gets to be very creative, right?
And let me ask you a question, since we got into something very, very particular. The audience we may lose some of the audience may have fallen off by now, but if you're still listening, what about the step up in basis? Let's
Yes.
talk about that. That would happen in the event, we're talking about in the event of obviously of the still example of a parent passing away,
Right.
et cetera, et cetera. That still happens, right? For capital gains reasons. They get that because of the.
Correct. The step up in basis, assuming the parent owned it individually, right, will happen at the date of death, right?
Yeah.
But siblings don't have any of that, right? So once we have sibling co-ownership, so if I'm buying out my brother, my property taxes are going up by the percentage that my brother's property I bought out, right? Whereas if I'm getting it from my parent, I might be able to keep my property taxes. And again, so depending if are we community property, we'll have an extra step up in basis, right? There's all, again, you can get into the weeds really quickly.
We can have several more episodes just on little sections of this. But for now, let's leave it at that. And let's talk about something that fascinates me, which is your story. Where did you grow up?
I was born in Covina, California, right? So I'm a Southern California girl. I went to high school in Glendale. I went to UCLA, and then I got out to Westlake Village. So I have slowly crept west.
Go west. Very good. Very good. Tell us how your journey to becoming an attorney. It was not when you were 15 years old, I'm going to be an attorney, I'm going to law school. This is not how you became an attorney. I find your story particularly inspiring. Share with us what happens when you were in college.
I didn't plan any of this. So I went to UCLA out of high school. I went to summer school right before school started. I was a psychobiology major. I wanted to be a psychiatrist, right? And that summer school of my first year of college, I met my first husband, I got pregnant, and I dropped out of school. So definitely wasn't my plan or my parents' plan, I can tell you for sure. And so I had to go get a job, and I had to start raising a family. I got a job in the title company, right? In the title and escrow business. And as soon as I got into real estate, I loved it. I love real estate. And so I just had to figure out where I fit in it once I was in it. And so I went from title to escrow, and I did escrow for 15 years.
How did the transition happen? I mean, which is relative, it happens to a lot of people to go from title. In your case, what was the thing that made you go from title? Because you were a title rep, you worked in marketing at title?
I did customer service. So
customer service.
I did labels for realtors, right? Farms.
Yeah. Farms. That's
that's realtors send out postcards, right? And the title company give them the contact information. So I printed labels, right? But as you can imagine, that's probably not the highest paid job at the title company, right?
Right.
So it was not. It was a minimum wage job. I liked it and I learned a lot, but I wanted, what was the next step? What was the next step? So the escrow officers in my office all had nice cars and nice jewelry and good husbands. And I was like, how do I get over there?
Yeah.
So I got into escrow because it was economically a great place to be. It is. Escrow professionals are commission-based, right? So if you're a good communicator and can generate business, you can do very well. And so I learned how to market and sell by getting into escrow. Yeah.
Nice. And then from escrow, the journey did not stop there. You almost say like, and then I went into escrow. Okay. But that was just the beginning of the journey, really.
Right. Well, during that time, I went back and got my undergrad from UCLA. It was one of those, I'm so excited. I go get my degree, but the best job I could get when I got out of my undergrad was to go back into escrow because again, it's commission based. I could make a lot more money in escrow than right out of college job with a poli-sci degree. Right. So I went back to escrow after I did that. And so, but I knew I knew that wasn't where my future, it wasn't where I wanted to be in the end of the day. And so then I went back to law school and I worked full time in escrow and went to law school and finished up that journey and got to, where I'm at today.
That's wonderful. I bet that working and going to law school must have been challenging, to say the least.
Trying to raise a child, working and going to law school was definitely a challenge. But it definitely, I wouldn't change any of it. I'll just say that, right? The challenges that the choices I made put in my path made me who I am today, right? And helped me in the problem solving, and what I do today is all a reflection of those choices, good and bad, right?
True.
So it is definitely been the building blocks to where I'm at today.
That makes sense. Now, tell us a little bit about your firm, what you specialize in. You're the principal. So tell us about, you passed the bar.
Yep.
And now what?
Law school teaches you how to think like a lawyer. Law school does not teach you how to practice law.
Right.
They're not the same thing, right? So I have all these great theories. If you ask me a question, I'm going to be able to answer your question. Socratic method, right? All that lovely stuff, right? That's what law school does. But it doesn't tell you how to fill out a form
right.
or file a complaint and getting it through the bureaucracy of our court system, right? And so I worked for 5 years for another law firm and really, got my bearings and really learned how to be a lawyer. And then I went out on my own. And so I've been practicing about 10 years for myself. I was, I'm remarried from my first husband, and my second husband and I wanted to have kids. And so, starting a family again. So I have a 29-year-old, a 10-year-old, and an 8-year-old. With that, I started my own firm because I wanted to have more freedom, right? I was going to raise kids, and I will say that didn't work. I don't have more freedom, but I do work for myself, but I'm a really bad boss. From that perspective, I'm pretty demanding, right? And so I started my own firm. It was just me at my house when I started. I hired my first employee a week after I gave birth to my second child. And today I have 11 employees, 5 attorneys, and 6 staff besides myself. And we have a thriving real estate practice.
Wonderful. So what is your typical client? Give me an idea of who your typical client is.
Well, I litigated partition actions, right? So consumers with real estate disputes or contractual needs are definitely in our wheelhouse. But my focus has been businesses and professionals in the real estate space. Based upon my background and escrow experience, I put a lot of effort into marketing to those people I knew: escrow companies, title companies, real estate brokers, developers, investors. So we're outside general counsel for over 400 escrow companies in California. We represent about a dozen title companies, about 50 brokerages. We do subdivisions. We work with developers, right? So we really focus on that real estate space. It is uniquely situated in business because of what we do. So we have a bunch of extra rules. I'll start using acronyms, RESPA and TILA. And
of course,
real estate is very highly regulated. So you need a specialist if you're going to be in this industry business-wise, or you're going to get in trouble unintentionally, right? And so that's where we're so well situated is, business attorneys can do the business part. We're not unique in that regard, but we're unique in being able to give you that specific real estate focus. And it's a different thought process on problem solving and all of that.
That's wonderful. I love to hear that. Before we wrap up, there is something I love to do, which is I'm going to tell you how it works. I have a list of 30 questions, and you have to pick a number between 1 and 30. And I will ask you that question so our audience gets to know you a little bit more on the personal level.
Sure.
All right, pick a number.
21.
21. What is the best Halloween costume you've ever worn?
I was a peacock one year. Right?
Oh,
so
nice.
When I was a kid, my dad had like a ranch out in Rancho Cucamonga area, and they had peacocks.
Oh,
and
wow.
Their feathers fall out, right? And so we collected the peacock feathers, and I made this whole a peacock costume. It was great.
Oh, wow. That's awesome. Do you have any pictures?
It was so, I don't know. It was a long time ago, but yes, that was a unique, right? Not something you saw out in the street.
I love it. Your entrepreneurial spirit was already showing at such an early age.
Exactly. Think outside the box, right?
Exactly. Okay, pick another number.
Okay, 8.
What profession other than your own would you like to attempt?
My husband and I have always talked about, like, when we retire, Having a business related and into bourbon. So my husband is from
Oh,
Southern Indiana, right near Louisville, Kentucky, which is bourbon country. And so we have talked about, I don't want to make bourbon, that's a lot of work. But bourbon is a huge industry there, right? And tourists, and so having a
right.
part of business and having people and helping them learn and enjoy their, the world of bourbon, I think would be a lot of fun.
That's awesome. So looks like kind of like a bed and breakfast in near bourbon country. Yeah.
Correct. Where we do
That's
tours
awesome.
and dinner parties and, enjoy the pleasures of that world.
I love it. I love it. All right. Before I let you go, we are gonna have in the show notes below, we're gonna have all the information of how to get a hold of you. But can you tell us if somebody is looking for an attorney in your area of practice, how do they get a hold of you?
Yeah, so our website is www.relawapc.com. So that's usually the easiest way to get all of our contact information. But I'm very active on social media. So you can find me. It's Jennifer Felten Esquire on LinkedIn, Facebook, and feel free to friend me and ask me anything you need.
That's wonderful. Thank you so much for joining the show, for being and for sharing your story with us, which I find incredible. You are who I want to be when I grow up now. I love your journey. I love the fact that you got your law degree as an adult, and I think that's wonderful. So thank you so much for being here, Jennifer. It's been a pleasure to talk to you.
Thanks for having me, Matias.
And I will see everybody on the next show. Thank you, everybody, for joining us. Goodbye.
Bye.